the thing to do is have a legal fee arrangement put in writing and signed by both parties. There are several reasons for doing this. In one class of cases, in contingent fee arrangements, the Kentucky Bar Association rules require that the legal services and the contract concerning those be specified in writing. And that's certainly good. It's a good rule, and it's a recent rule, and it will probably clear up a lot of things in that area of practice involving lawyers' fees. But it's a good practice in all cases except for small matters to have a written fee arrangement. It keeps the agreement clear all the way through what it is, and it protects both parties. A lot of times in extended litigation there will be so many things happen that appear to be much more important to the client than even the fee that the lawyer charges. And there will be a lot of things happen to the lawyer that appear to be much more important than the amount of money that he's getting out of it. And sometimes you forget, actually, what the discussion concerning the fee has been if it's not put in writing. And so it's certainly the benefit of both parties that it be done in that fashion. Now, then I want to discuss particular types of cases like I referred to a little while ago, and the type of fees that lawyers either customarily or by ethical rules or a rule of law that how they charge. There are some classes of cases where that the lawyer primarily works for a set fee, that is some prearranged fee that is either partially paid in the beginning or all in the beginning or all at the end, but a prearranged definite amount of the fee where it's set. And it doesn't have to be all written in stone, but it certainly should be really definite, set up in a definite manner. And examples of these types of cases are criminal cases and divorce cases. There's some good reasons for the fees being set fees in these cases. And part of the reasoning is, and I've just assumed this over years of practice, but it's my understanding that this is the reason for it, that in criminal cases, a lawyer should not do any less than his best in any area of the defense of his client in a criminal case. So the law does not provide or allow him to charge a fee that would be more rewarding if he won than if he didn't. Now that's one reason it's always seemed to me, so that there's no speculation involved in what it's going to be. Another area of cases where that no contingent fee is allowed, but a set fee must be charged, are in divorce cases. You cannot charge a contingent fee based on the amount of recovery or anything similar to that. And there are ethical rules prohibiting that. And again, it's something that's really for the protection of the client. The rule that is for the protection of the client. And some of the reasoning, same reasoning, it seems to me that's in the criminal cases, a reasoning for the rules in these cases. Now, when I say a set fee, and I said a minute ago that it's a certain amount, but it does not have to be one definite amount. The lawyer can charge based upon his actual time spent and documented of a charge per hour, and you can have a prearranged agreement concerning the amount of what the hourly charge is going to be. And then, of course, the client does not know until the end how much that fee is, the total amount is going to be, but he or she should have an idea based on the amount of time that's been involved in the litigation or whatever it is, of how much is going to be charged. And then the lawyer can handle it by monthly billing so that the client can be apprised of how the charges are running, and so the lawyer can collect part of his money as he goes along, as he's expending his own time in the case. Now, then there are some areas of cases where the fees of attorneys are set by statute. A couple of these areas of cases are workers' compensation and Social Security. In workers' compensation cases, the law sets a maximum of 20% that a lawyer can charge as a contingent fee for representing the workers' compensation claimant. That is a maximum fee that the lawyer can charge. Then there is a cap or a maximum total that the lawyer can charge for the whole case. In addition to that, the statutes provide that the attorney representing the workers' comp claimant must file specific documentary evidence of the amount of time and effort that he or she has expended on the case. And then that must be submitted to the Kentucky Workers' Compensation Board for their review and approval. So that's a statutory procedure, and if a lawyer doesn't follow that, he may have to give up the whole fee that he was expecting at the end. And that is for the protection of injured workers, a special protection so that it will be assured that they will not be forced to pay too much for the legal services due to the situation they're in. Then in Social Security cases, the rules are a little different based on the federal statutes involving this. The lawyer may charge, he may charge a set fee, or he may charge by the hour, or he may charge on a contingency fee basis. But any fee that he or she charges must be documented again to the administrative law judge who heard the case. And then it is subject to the law judge's approval, and only the amount that's approved must be paid by the client. And the Social Security Service generally assists in this by withholding part of the back pay of the claimant, and for the protection of the lawyer and the claimant. But any fee that the attorney charges must be approved by the Social Security Service. So that's two classes of cases. Now there are others. The Veterans Administration has very stringent rules concerning how a fee may be charged in those cases. And surprisingly enough, long extended litigation may have a cap of only a few dollars on it in Veterans Administration cases. Then let's go on to the contingent fee agreements when they're used. This is one of the areas in charging that is probably the most controversial in how lawyers do it. And it's something to me that is a vehicle or a method that can be used to the advantage of both parties, of both the attorneys and the litigants, the people who are involved in the clients. Now, what is a contingent fee arrangement? Well, a contingent fee arrangement simply is an agreement whereby the lawyer charges a percentage of the recovery of money which he gets for the client if he recovers anything, and nothing if he does not. Customarily, these charges run about 25% of the amount recovered on a settlement, about 33 1/3% of the amount recovered if the lawyer has to go to court for the client, and about 40% if it goes on to appeal. But let me again state that this is not anything that is set. There used to be what was called a minimum fee schedule for lawyers. It was recommended by the bar associations. But federal litigation involving a number of areas has caused all of these to be thrown out as being in restraint of trade. So there is no set recommended fee that any bar association will recommend. But this is just a rule of thumb that a lot of lawyers and clients go by in arriving at what is a fair fee in these cases. The bar associations has a number of standards to go by in determining how much to charge, and I probably can't repeat all those off the top of my head without having the list before me, but among those are how often